either.
All right, Derrin, you want to start?
Go. If you would roll to the first couple slides, Derrin, I'll do some
Be my guest.
Okay, good afternoon or good morning, everybody. Your presenters today are going to be Ilene Ferenzi and Derrin Watson. To give you a quick rundown in case you don't know who they are, Ilene is the managing partner of Ferenzi Benefits Law Center, an employee benefits law firm in Atlanta, Georgia. Ms. Ferenzi advises clients on all types of employee benefit plans, particularly focusing her practice on qualified retirement plans, benefits issues and mergers and acquisitions, and advising third-party administrators of employee benefit programs on technical and practice issues. Having become an attorney after more than 10 years as a third-party administrator, she brings a unique and practical approach to her advice. She's a member of the state bars of Georgia and California and holds designations as CPC from ASPA and APA from NIPA. Ilene is also the author of our qualified plan e-source on ERISApedia.com. Derrin Watson is an ERISA attorney and pension educator in solo practice in Santa Barbara, California. He received his bachelor's degree in accounting from BYU in 1980 and the law degree from UCLA Law School. He is the author of Who's the Employer? A Guide to Employee and Aggregation Issues Affecting Qualified Plans, with the 7th edition released this year and now exclusively on our ERISApedia.com platform. He's also the senior editor of the Journal of Pension Benefits and is of counsel to the Ferenzi Benefits Law Center. His varied experiences range from doing stand-up comedy, yes, even about ERISA, to serving as a Mormon missionary in Iran, to editing and writing books and newsletters on a variety of topics. Today, I'm your host. I'm Chuck Gouge, and on the next screen, Derrin, it'll show my pretty picture. That is more recent than the one you were just looking at. And Joanne Pacina is going to be monitoring our question board. You should find in the toolbar on WebEx, you should find a place where you can send in a question. Next slide, Derrin, if you would. All your lines are muted, and by now you've probably figured out if you're listening to this that you needed internet audio, because with this big of an audience, WebEx can't handle phone calls. We will try to answer some questions as we go, so please do send in questions via the chat or the question board. If we can't get to all of them, we'll try to summarize things at the end. Slides and recordings of this webinar are going to be available from ERISApedia.com/webcasts on our webpage. I presume you've turned on the record button, Tim.
Yes, I have this time.
All right.
Yes, thank you.
And certificates for CE credits will be sent out in a few days. Please check your spam folders. These come from, I think, do not reply at ERISApedia.com. So sometimes that gets caught up in spam. So please do look in your spam folders. It takes a little bit longer for ERPA credit, but the other certificates for ASPA and NIPA come out pretty quickly after the webinar closes. I think that's it, Derrin, so I think you can take it away.
Greetings, welcome. Thank you so much for joining us. And let me tell you what we're going to be doing today. After this introduction, we'll be talking about what ethics is, where we get our ethical guidelines that apply to us in the retirement plan world, and a few other considerations. And then the most important thing we'll be doing is we'll be having some discussion about some case studies, and we'll have a number of questions for you. Just to illustrate the questions for you, we're going to be using the WebEx polling feature, and we have our first question of the day. If you have a bunch of people there, pick an answer between you. This particular question is, check all that apply. Why are you attending this program? Possibility A, I really need to brush up on my ethics. B, it's a required continuing education topic. C, you can't beat free. D, I love listening to Ilene and Derrin. E, I want to know how close to the ethical lines I can get without going over. And F, I'm looking for practical advice on ethical dilemmas affecting my practice. So plug in your answer. We have about half of you have done so. That's great. Keep plugging it in. We'll give you another minute. Until we've got about 90% of you answering.
It looked like, Derrin, we've had a couple people that have walked away from their desk after it started.
Well, you know, that's one of the other possibilities that come here. All righty, I'm going to close this in about 10 seconds. So log in your answers, please. And this will show that you understand how the polling works. So let me now show you, giving just a few seconds for the last couple of ones to come in. 4, 3, 2, 1. Let's show you the results. So the majority answer is it's a required topic. I am personally honored that a third of you said, I love listening to Ilene and Derrin. That's always good to hear. 40% of you realistic enough to say you can't beat free. The most important response here is only 3% of you said, I want to know how close I can come without going over. If we had much more than that, I would be seriously concerned about the ethics of the people here. But that says things are about where they stand. Now, seriously, let me go to the last one. I'm looking for practical advice on an ethical dilemma. If you want to put into the Q&A box a question dealing with a practical dilemma that you face, I don't know that we'll get a chance for it, but you're welcome to put it in. In any event, let's launch into things. Did you wake up this morning saying, gee, I really want to be an ethical human being today? I didn't. I do wake up on occasion saying, I want to be a decent person today. But my own sense of what constitutes being a decent person doesn't come from Circular 230. You know, it comes from what my mother taught me growing up, and what I've learned at church, and what I've the opinions I formed as I've lived my life, and my sense of right and wrong. Fortunately, the obligations of the various ethical rules, which tend to be something that's imposed by a third party, fairly well latch into all of that. They help refine our understanding of what should be going on. Ethics, according to the dictionary, is a discipline dealing with what's good and bad, and with moral duties and obligations. In other words, ethics flows from our our sense of morality. They should run in together. There are a variety of places we look for ethical rules. Various professional societies have their own standards. For example, I'm a member of now it's the American Retirement Association. When I joined, it was the American Society of Pension Professionals, and then became the American Society of Pension Professionals and Actuaries. I always was fascinated by the name change, the addition of the extra P. The actuaries were not pleased. The American Society of Pension Professionals and Actuaries, and they said, what are we? We're pension professionals. It sounds like ladies and gentlemen, and you too, Jack. It rub books. I had a solution for it. We should call it the American Society of Pension Professionals and Professional Pension Actuaries, but they simplified things. They're the American Retirement Association. Anyway, they have a set of ethical guidelines that you're supposed to follow as a member of the society, as does NIPA, as does a variety of other associations. For me, as an attorney in California, I find myself answering to the state bar, and I need to make sure that I follow the ethical rules laid out by the California State Bar. I am also a practitioner before the IRS, and as such, I need to adhere to Circular 230. One of the intriguing things about all of these various ethical standards is that they help to define the standard of care in an industry. They're not the sole source, but they certainly help to define what is the industry standard for the way people ought to behave. We're going to talk in a little bit about a rule from Circular 230 that isn't a rule the IRS can enforce. It says this is what we aspire to. This is what we ought to be, but we can't discipline you if you're not. Well, a court can take that into account and say, this represents the appropriate standard for what an industry ought to be doing. And the standard of care that ought to apply. The key difference between what your client is expecting of you and what you are expecting of yourself can lead to a malpractice suit, can lead to your client thinking that you have not done the things that they hired you to do. And the client has all kinds of ways of coming up with their ideas of what you ought to be doing. And you see some of them listed on the screen. Down at the bottom, legal documentation such as your service agreement. I like the placement of this. All right, the slides, the great illustrations. Let me be ethical here. Thank you, Ilene Forenzi. Ilene does just a bang-up job with coming up with slides for our joint programs.
It takes me hours to draw them by myself.
Yes, indeed. But Ilene, were you deliberate in putting legal documentation at the bottom of this list? Or did it just happen that way?
I think it just happened that way.
But, honestly, I think in terms of what the client has in their mind, the paperwork is probably at the bottom of the list.
Yeah, I think you're right.
But that said, in terms of being able to say, I did what I promised to do, obviously that piece of paper matters a great deal. We're going to be focusing on the ethical obligations that are imposed on us by the IRS, and we find those in Circular 230. They govern enrolled retirement plan agents. The door is closed for them now, but those who got in before they closed that door still have their authority as IRPAs and still need to satisfy it. But it also applies to attorneys, accountants, enrolled agents, anyone enrolled actuaries. Anyone enrolled to practice before the IRS, and the IRS has gone further to say it applies to anyone who in fact practices before the IRS. And so we're going to be focusing on the Circular 230 rules because it is what we all share. As attorneys, we may have different obligations and responsibilities than does a TPA. But we all practice before the IRS, and so this represents our common set of rules. And I'm for the most part, I'm going to ignore the actual references in Circular 230. But if you want to go there, you can find out. You can read specifically the guidance there. Among the various rules, when the IRS asks us to provide information, we are to do so promptly. We are not to unreasonably delay the matter unless there is some reasonable ground that the matter is privileged. As a practical matter, as TPAs, I'm guessing that most of you here are TPAs. The things that you have are seldom privileged, which is why if you've got a client where you're concerned that they might have committed a crime, you might very well want to have a criminal attorney involved. Please, I don't want any jokes about the term criminal attorney being redundant. You might want to have a criminal attorney involved and to be engaged by that attorney so that you have the benefit of the attorney-client privilege, because as a TPA, you don't particularly enjoy the benefit of any particular privilege. The IRS is increasingly expecting that we're going to adhere to this, that we are going to respond promptly to their requests for information. They are very limited in their willingness to grant extensions. Ilene, from your practice, how important is the response to the document request that you get from the IRS in an audit situation?
Well, nowadays it's gotten really important, not just in audit situations, but also in the voluntary submission situations. The IRS has been instructed by, the people that we talk to have been instructed by their superiors that they are to strictly enforce the deadlines that they give and to basically consider you late and take whatever action they can that's punitive if you don't do things on time. So nowadays, if you're going to be late getting something to the IRS, it's really, really critical that you call them before the deadline and get an extension of your deadline, because particularly like if it's a voluntary submission, they'll kick it out. And they'll do it without warning nowadays if you don't respect their deadline. So it's very important that you respond nowadays in the time frame they give you.
Yes. .34 is a very important rule. You can't advise the client to take a position that is frivolous, just intended for delay, or demonstrates intentional disregard of the rules and regs unless you have some good faith reason why you think the rule or reg is wrong. You cannot advise the client to submit a return that doesn't have at least a reasonable basis for the various positions on it, that takes an unreasonable position, or willfully understates tax or disregards tax rules and regulations. Now, for this purpose, surely the 5500 and its supporting schedules constitutes a return, and this is every item. So if you have a client that is 2 months late on depositing elective deferrals, and you have this question, 4A, were you late in depositing elective deferrals? There is only one answer, regardless of what your client may want you to say. You cannot advise the client to submit a return that lacks a reasonable basis. And in 2 months, there is no reasonable basis to say that it was timely. You have to advise the client of any penalties that are likely to apply to a position and inform the client of the opportunity to avoid such penalties by disclosure and the requirements of disclosure. Well, now, that's written primarily for income tax practitioners, where there are a variety of positions that, if disclosed to the IRS, you can reduce or mitigate the possibility of penalties. That's not so much for us. When I read these particular bullets for us, I think of the reality that many of our clients have mistakes in their plans. If you want to see a plan without errors, it was adopted 5 minutes ago. But after that, the errors start creeping in fairly quickly. Once you discover them, when we talk about informing the client of opportunities to avoid penalties, that to me says, here's what you have to do to fix your mistakes, including the possibility you need to go in under VCP. And to me, this is a command to at least inform our clients of the availability of various correction programs. One of the questions that comes up is, what's the difference between an aggressive position that one can reasonably take and a position that violates the rules? You're allowed to take an aggressive position. You're allowed to say, all right, I know there's this 1997 ruling by the IRS, private ruling, that says this, but I think they're washed up, and we'll go for, and here's why. And if you can honestly articulate a good reason, then you can go forward. What's the difference between that and something where, it's a dead bang loser, and you go to a meeting with 100 people and you ask, how many of you would recommend this to a client, and 99 people put their hands down? You say, my goodness, I may not have a reasonable position here. We have, as an example, a TPA has a great design idea. He goes through the code or regs, can't find anything to suggest that the idea is wrong, but there have been 5 cases in the last 10 years, roughly similar to that idea. They've all been decided against the taxpayer. The administrator had no idea of these cases. He's not a lawyer. Ilene, where do you come down on that in terms of it being an aggressive position or just way outside?
Yeah, I think that if you're going to be interpreting the tax laws, and giving a client advice as to something that is not settled law, then I think that you have an obligation to do proper research. And you can't be giving people suggestions that they should do things or take certain positions without doing the proper research. I think that that's inappropriate. So I really do think that this particular administrator would be in trouble because he didn't look through things thoroughly. And the fact that he's giving that level of advice without the knowledge of where else to look for guidance, I think, is indicative of the fact that he's in over his head. So I think that would be problematic on an ethical basis.
Let me add, Ilene used a very important phrase there, in over his head. One of the requirements that we'll get to, and it's actually a somewhat newer requirement, is the requirement that you only perform services that you're competent to perform. And so if you're going to come up with some really novel strategy, the notion of being competent to do what you're doing suggests that you ought to check it out, more than just a quick read of the code and regs and maybe a question on benefits link. That you need to thoroughly or at least reasonably understand the matter. In Circular 230, there's a very important statement that you can rely in good faith on the information your client provides to you. That is the practitioner's friend. You are not necessarily called upon to audit your client. That said, the next one is extremely important. You cannot ignore the implications of information furnished, and you must make reasonable inquiries if the information appears to be incorrect, inconsistent with known facts, or incomplete. In other words, you can't put your hands over the ears and say, la, 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 I can't hear you. You cannot disregard the things that are in front of your face. One of my most memorable cases when I was in more of a general tax practice involved somebody who was being audited by my state, California, regarding travel and entertainment expense. And yeah, he had a lot of travel and entertainment expense. But he said, I've got receipts for all of it. And he brought me this shoebox that was filled with receipts. Now, this was a number of years ago, and you didn't necessarily have the cash register receipt. What you had was that the server would tear off a tab from the bottom of the receipt, and it would have the total written on it. That's what this guy had, was this box full of tabs torn off of the receipts. Well, if you went through the stuff, you know, they were spending, you know, $125 for a meal. And yeah, even back in the 80s, 90s, you could spend $125 on a business dinner for two, someplace you're trying to present someone, impress someone. There's only one problem. The receipts were not from Ruth's Chris. They were from Denny's. And if you look closely, yes, the receipt was for $125, but the 25 was written in ink and the 1 was written in pencil. And I'm sitting here with, I cannot ignore the implications of information furnished. I must make reasonable inquiries if it appears to be inconsistent, incorrect, or incomplete. And once I made those inquiries, I ended up resigning from the case. You need to not take things at face value, but you don't necessarily have to audit your client. in terms of working with your clients, here's the one we were talking about a moment ago. You must possess the necessary competence to engage in practice before the IRS. And so the definition of competence, appropriate level of knowledge, skill, thoroughness, and preparation necessary for the matter. I like this next line. The practitioner may become competent for the matter for which the practitioner has been engaged through various methods, such as consulting with experts or studying the relevant law. So attending seminars is a way one gets competence, becomes aware of an area. So that certainly qualifies. Reading books certainly qualifies. Or mentoring, studying under somebody who knows it better than you do, which is, frankly, how most of us got our entry into the profession. I am surprised, and have long been surprised, with how many practitioners try getting into areas where they do not have the necessary competence. For example, there will be many times when somebody understands, knows 401k plans backwards and forwards, and they have a tax-exempt organization with a 457B plan that they're already serving because they also have a 401k plan. And the advisor says, well, how different can it be? Sure, I'm happy to take it on. And then isn't willing to do the work to really understand it and to be able to advise them competently. I'm terrified of such circumstances, and I have found it way too often in my professional career. You cannot agree to represent a client if there's a conflict of interest, where it will be adverse to another client, or there's a significant risk that it may adversely affect another client. The exception is you feel like you can handle both carefully, professionally, fully. You fully present all the facts about it to the clients, and each client, having received that information, waives the conflict in writing. Let me add, one of the most important things that you can do in understanding this is knowing and fully appreciating who your client is. But we will have some case studies that present some of the conflicts that happen just in the course of day-to-day administration that don't jump up necessarily and say, you have a conflict of interest, but that as a practical matter do. Understanding this person is my client, this person is not my client, is crucial to understanding that. Let me add, this is one of the good reasons you have an engagement letter, is so that we have it clearly understood who the client is. Ilene, would you like to add anything on this?
Just that it's harder to come up with conflicts of interest really in an administration or an actuarial kind of standpoint. The one thing I do remember for a relatively short period of time, who did a lot of divorce work, and if he was valuing benefits for both the husband and the wife in a divorce situation, he would have them sign conflicts waivers, because quite often he would be representing, for example, a doctor, and the doctor's spouse would need to have evaluation done, and he had an interest in keeping the doctor as a client going forward, so he could be considered to be biased in favor of the doctor waivers in those circumstances. That's really the only time I've come across a situation where I think that an administrator really needs to get a waiver, but I'm sure that other people have some circumstances that have come up in their practice.
Would you guys like to take a few questions?
Sure.
So one of the first questions, a client repeatedly remits 401k deposits late. After a couple of years of this and many conversations, nothing changes, so the TPA fires the client. Does the TPA have an ethical obligation to report this to the Department of Labor?
There is no rat out your client obligation in Circular 230. And so I don't think that you have to do that. And I would think that as sad as this sounds, if the person is remitting late and is always paying the interest and always paying the excise tax, and they're actually resolving the situation ultimately, they could certainly be sued at some point in time for a fiduciary breach, but I'm not sure what the damages would be in that circumstance. And so I don't know that there's anything necessarily to report to the Department of Labor at that point. What do you think, Derrin?
Yeah, that case certainly doesn't have it. I have heard of a case where the plan administrator was in the process of stealing the money from the plan and going to warmer climes, and called their advisor just before boarding the airplane to say goodbye. And in a case like this, yeah, this is a case to notify the Department of Labor, and because there were employees who were very seriously going to get hurt. That contrasts with what Ilene was just talking about. The DOL got him at the airport with the money in his satchel, I believe. But no, that would not necessarily stop it. I think Ilene's analysis to say it isn't that big a deal, but B, if they're correcting it as they go, what's the harm? Really influences my own outlook on this one.
Okay, and just one other question. Pardon me. You talked earlier about the possibility of hiring a criminal attorney in a problem situation. Could you restate how the attorney should be hired so that the TPA would be included in privileged discussions regarding information involved in the problem?
The notion is you need to get the client to sit down to engage the attorney, and then the attorney engages you to assist her in dealing with the matter. So you are now on the attorney's team, and that's how you can become covered by the privilege. Ilene, you want to add to that?
No, I think that's exactly correct. I think that you really want to be careful about this stuff. There have been some cases, and I've talked about one in like the Keeping Current sessions that we do all the time, where basically there was somebody who was not an attorney in the room, and the person wasn't hired by the attorney, and discussions happened, and the entire notes and everything else of those discussions was discoverable in litigation because they didn't protect the attorney-client privilege. So that would be the way that you would do it, and you would have to be very careful as well. So, yeah.
Okay, great. That's all we have for right now.
Cool.
Great. Moving on then. All right, no false advertising. Among the things that the IRS considers to be false advertising is using the word certified. If you're an IRPA, you are not certified as an IRPA. You are enrolled to practice before the IRS, and that is the term that they want you to use. Your fee information cannot be misleading. Including in that is if you state a fee, you need to stay with it for at least a month before you increase your fees. If you read this slide. and think about what's missing here. If you know the client has omitted material, important information, or made an error in any filing with the IRS, you must advise the client that you know of the error and the potential consequences of the error. What's missing? What I think is missing is resign from the case if the client refuses to act. That is not a requirement that the IRS imposes on us.
You also don't have the requirement that they have to amend the return.
There is no.
That comes up a lot, you know.
I find that one intriguing. That there is no legal requirement on the client to amend the return. Now, as a practical matter, one may wish to do so for a variety of reasons. But you know, if there's a $100,000 error on the Schedule 8 balance sheet, yeah, I'm probably going to recommend that the client amend the return. If there's a $50 error, it's not material.
And it also determines like how many years ago the error was made on the 5500. You take over a case and you discover that 2 years ago they made a mistake on their 5500, and it wasn't a substantially misleading issue. It was just I don't know, something that would not cause anybody huge pause. Are you really going to go back and amend a return from 2 years ago for this thing that really isn't that material? Probably not. And you have no ethical requirement that you force the person to amend in that circumstance.
But this, again, in my mind, goes beyond a return. Everything that we do in handling a plan, in one way or another, ends up affecting the sum entry on the 5500. So to me, this goes beyond the return to plan operations. If you know that your client is messed up, you're required to let the client know, or you're not. It may not even be your client messed up. If you're aware that there's a problem with the client's plan, you have the obligation to make your client aware of it. And again, when I think of the potential consequences of the error or omission, I think of yes, ultimately we can disqualify your plan, but realistically what you're looking at is correcting the problem. So in an employee plan standpoint, the potential consequences of the error are you got to fix it. And that then to me is part of what propels a great many discussions with our clients about what's going on. Ilene, you want to add to that?
Nope, I think that you got it.
You have to exercise due diligence in your practice. You can reasonably rely on somebody else's work product, but it depends on the circumstances of the arrangement. If they're one of your employees, we're looking at, or an independent contractor that you've engaged, what level of supervision, training, experience, etc., goes into your relationship with that person. If you're looking at it from some outside third party, you are to reasonably evaluate the work product. I've seen in the course of my career a great many legal opinions, and many of them are things that have left me educated and informed, and I've come away after reading the opinion saying enlightened. There are a bunch of opinions I've seen that I would think twice about using them to line my cat box. They are that bad. And you need to be able, to distinguish what you can rely on and what you can't rely on. But all of that is part of exercising due diligence. Now, this section 10.33 that we're talking about in the next few slides, these are, I mentioned this earlier, these are goals that are set there that the IRS can't necessarily enforce. You can't be disbarred from practice before the IRS. You can't lose your IRPA credentials if you don't do this. But a court in a malpractice suit might very well say these are the standards of practice that you ought to be following. Your goal should be to provide clients with the highest quality representation by adhering to best practices. You are to communicate clearly with your clients regarding the terms of your engagement. Eileen, this is an important part of what you do. Do you have a comment on that?
Yeah, I do. If anybody has ever heard me speak before, you know that engagement agreements and service contracts and the like are very, very important, I think. I think that they are the main area of liability protection for TPAs, and I think it's very important in terms of your management of your firm to have a really good service agreement. And I think that with this as being a best practice, I mean, I think it's really clear that the government feels the same way. It outlines what you're going to do, what you can be held responsible for, and also what are the responsibilities that you leave with your client. And I think that's very, very critical. So I think that anybody who practices without an engagement letter is just silly. And I think that they are risking lawsuits for things that they have not intended to take on. So I can't really say anything stronger than that.
Let me add to it. When she said it outlines the things that you have left in your client's domain, that means the things you're not going to do, all right, and therefore you are not responsible for. And so here's what you are paying me to do, here's what you are not paying me to do, and that I'm not doing unless we come to some other arrangement. And I agree that that's critical to what you're doing. As you advise the client, you're to establish facts, determine which facts are relevant. That point is remarkably important and easily overlooked. I've had a lot of people who look at a rule in the code, and the code says X. It says, thou shalt pass the ADP test. And they say, but what about my situation? It doesn't specifically say, in my situation, I have to pass the ADP test. It just says it in general. And I don't think in my section, in my particular situation, I should have to pass the ADP test. And that, when that is presented to me, by the way, most often it is presented as, show me some regulation that tells me that the general rule applies to me. And my almost invariable response is, show me some regulation that says it doesn't apply to you. Show me something that says if I wear green overalls, I don't need to follow the rules. Because you need to sort between the things that are relevant. Well, I have a safe harbor plan. Well, I don't have any HCEs in the plan. Sort between the things that are relevant and the things that are irrelevant in coming to your conclusions. Evaluate the reasonableness of any assumptions or representations. In other words, although you don't have to audit your client, you at least have to have your brain engaged when you listen to your client. Relate the law to the facts, arrive at a conclusion, advise the clients of your conclusions, and act fairly and integrity with regard to the IRS. Let me add, you also have to act fairly and integrity with regard to your clients. Your clients own their records. You are required to return their records And a fee dispute doesn't relieve you of that obligation unless state law allows you to retain records that pending a fee dispute. Those records include anything that your client handed you before you started working for them. Yeah, and I would include in that anything that the last TPA handed you before you started working for them. Anything your client prepared, and any claims that you've already done, returns, etc., but not necessarily those for which you're still waiting for payment. Circular 230 also talks about running your own practice. Going back to the best practices, if you're an owner or manager, you're supposed to take reasonable steps to ensure that the firm's procedures are consistent with those best practices. You're to take reasonable steps to ensure that the firm has adequate procedures in effect for all members, associates, and employees to comply with Circular 230, and the IRS can discipline you if you haven't done this. There used to be a lot more detail with regard to written advice, and there was a separate section, 10.35, that dealt with written advice, and that's now gone. But there is a broader section, 10.37, that is the current standard. When you're giving written advice to a client, you have to base it on reasonable factual and legal assumptions, and you have to make a reasonable effort to get the facts. Consider what you know or what you ought to know, not rely on something that isn't reasonable, and you have to relate the law to the facts. Very important. The IRS doesn't want you to answer the question your client keeps on asking you. You may not, in evaluating a federal tax matter, take into account the possibility that the return won't be audited or the IRS won't catch it on audit. You're not allowed in giving written advice to do that. Federal tax matter. Go down to the bottom. Any other law or regulation administered by the IRS. I think that's everything we do. I think anything dealing with the Internal Revenue Code is included there. One of the interesting things about 10.37, and this is a recent amendment, is it defines what constitutes reasonable reliance. Reliance on what your client tells you or what you get from third parties is unreasonable if you know or reasonably should know that it's incorrect, incomplete, or inconsistent. So once again, there's this standard of reasonably should know. So your brain is required to be engaged. You can rely on another if the advice is reasonable and the reliance is in good faith considering all facts and circumstances. Oh, yuck, a facts and circumstances test. But your brain has to be engaged and you have to be careful. Ilene, would you like to add something here?
Yeah, I just wanted to mention one of my favorite cases I talk about in this regard has to do with a doctor group. They were a radiology group, and they were located in a city some distance away from where I am. So I represented them for a period of time before I actually met them face to face, and they told me they had no employees, and I was fine with that. It's not uncommon that a radiology group would have no employees. After a year and a half or so, they had me out to their offices. So I go to their office, and they're in a hospital. And I go to this area, and there's this big, archway that says radiology across the top. And underneath this archway is a desk, one of those sort of receptionist desks that you see at hospitals with two chairs at it. And I was there after hours, so there was nobody sitting in the chairs, and the doctors were in the back in their little meeting room. And I said, who sits in those chairs? And they say, Sue and Donna. And I say, didn't you tell me you had no employees? And they said, yeah, well, no, they don't work for us. And, here's a situation where they've got the radiology group, they've got a dedicated desk, they've got 2 secretarial chairs in the front of the area. That, to me, is a really good example of a situation that you can't take what they're telling you at face value. And sure enough, after I talked to them, it became really apparent to me that they were leasing these employees from the hospital. And so I got all ready to talk to them about the fact their plan had probably not been in compliance since 1904. And they proceeded to tell me they'd been audited by the IRS 2 or 3 years earlier, and the IRS had not raised the issue. And I said, well, surely they didn't visit your offices. And they said, oh, no, they were here. So it's like, what are you going to say? Maybe the next auditor won't be so stupid? I don't know what else to say to that. But the fact is that, I had to discuss this with them as being a real problem, that they were out of compliance. So that's just an example of not ignoring the things that are right in front of your very eyes.
And I had a very similar case recently. It was dealing with an affiliated service group matter. And the client said, oh, yeah, these 2 companies have nothing to do with each other. And just for fun, I did a quick internet search, and I found that the 2 companies shared a website and sent circulars around the neighborhood advertising their services together. Oh, yeah, they don't do anything with each other.
They don't even talk to each other. They don't know each other. They don't recognize each other on the street, right?
And who are you going to believe, me or your lying eyes? You got to think about these things. Reliance is not reasonable when you know or reasonably should know that the opinion shouldn't be relied on, you know that the other person, or should know, isn't competent, lacks the qualifications to provide it, or you know or should know that the other person has a conflict of interest. Written advice includes email. It doesn't include continuing education or that kind of generalized stuff, but it includes specific comments to the clients. Very important, a disclaimer does not take you out of this. So putting a disclaimer at the bottom of your email is not either required or helpful in dealing with these written advice requirements. However, you may want to have a disclaimer to indicate how far your opinion goes. We're not going to take the time here, but this is an example of such a disclaimer. When I see somebody with an email, and I got one Friday from somebody who is a reputable tax practitioner that has a circular 230 disclosure at the bottom of it. That particular provision that they are citing has been repealed for 3 years. And to me, the fact that they include it says this person is not staying up to date, and says to me, I'm going to regard anything they say with not a grain of salt, a box of salt. This person has already demonstrated by that disclaimer that they are less than trustworthy.
Yeah, and I will say that I have heard the IRS say in continuing ed sessions where they talk about this, that they consider it unethical to have that kind of disclaimer anymore because it purports to disclaim something that cannot be disclaimed. So they consider that to be unethical. So it's interesting that just their very email is like demonstrating a lack of ethics, at least according to the IRS.
Couple of last points beyond IRS discipline. Of far greater importance is your reputation with your clients, with other practitioners, with your employees. Let me add, with the IRS and with the Department of Labor. we're in a really, comparatively speaking, a small community, and word gets around quickly. Your reputation as somebody who is a straight shooter, who plays hard but plays fair, is invaluable. Your personal ethics, you've got to be able to look at yourself in the mirror the next
I have to tell you, yeah, I mean, it's huge from a personal standpoint, that, to me, I just, I have to go look at myself in the mirror and know that I've been honest. But besides that, I mean, I can't tell you how many times I've heard from governmental representatives, I've heard from other representatives, Eileen, that your firm, works with us, and that you're honest and that you're timely, and blah blah blah, and it changes the way that they are thinking of us, or at least it helps the way that they're thinking of us as they deal with us, and it's just incredibly helpful. So I mean, I would definitely tell you to value that reputation zealously.
Amen. Let me add, as a practical matter, all right, one, don't let anyone else take away your good name. Sit there and make sure you protect it, because it's a valuable asset. And if you're in doubt, and you do have situations where doubts come up, consult with a trusted friend. Have you ever had a situation in your personal life, with relationships, with finances, with something that you sitting in the middle of it, don't know what to do, but if your daughter, your best friend, came to you with the situation and said, "What should I do?" you would know exactly what to do. But when confronted with it yourself, you end up saying, "It's complicated." It is important to be able to say, "I am doing what's right," and if you're not confident of that, then have a trusted friend who you feel like has a fairly good moral compass, a fairly good ethical compass, and say, "What should I do?" Because they can sit in that role as the outside party and say, "Oh yeah, here's what you need to do." One of the things I have enjoyed most about my relationship with Ilene over the last, closing in on 18 months that I've been of counsel to her, it has been that ability to go to her and to say, "I've got this situation," and she will immediately say, "Well, you got to do this," and having that kind of clarity is just invaluable. With that, ladies and gentlemen, we're now going to move into what I think is the most fun part of what we're doing here, and that is to talk about, to give you some illustrations and give you an opportunity to take a look at them and think of what you would do in these particular situations.
Derrin, right before we get into that, there was two, I think, interesting follow-up questions to the questions we discussed earlier. Let me just run through that real quick. So the first one was following up on the TPA who fired the client who had the late deposits for 2 years. Says, following up on the late deposit question, what if a participant calls you, the TPA, and raises questions and concerns about the late deposits? What should you tell the participant? Send them to the Department of Labor? ?
So here we get to a conflict of interest. Eileen, do you want to handle that?
Yeah, well, I was going to say, one of the things that we put into service agreements, because it's really important in this circumstance, is whether or not it's part of your agreement that you talk to participants. Remember that you get paid by the company, And so it may be that they consider what they say to you or what information that you have to be confidential, and you don't want to be put in a position where you're giving out confidential information that you shouldn't be. So one of the things that you might want to consider having in your service agreement is something that says whether you will or will not communicate on behalf of the company with participants. Having said that, if you are supposed to talk to participants and they've authorized you to do so and the participant raises concerns about this, I would probably say first, I strongly recommend that you talk to your company, talk to the employer and see what's going on. If they were to then, come back to me and say, okay, I talked to the employer and they sounded really dicey, then I think that you are in a position where you have a certain obligation to let them know that they have rights that can be enforced and that they can certainly do that. I think if you cover that up, then you have some risk that you can be sued for giving the person advice that wasn't appropriate. So I think that you need to be able to do that. On the other hand, like I said, normally I would protect myself from being put in that position by saying in the agreement with the client that I'm not going to talk to participants, and then I would say to the participant, I'm really sorry, I work for the company and I'm not authorized to talk to you, so you should go back to your HR department.
And so, Ilene, in this particular situation, if I'm remembering the first question, the TPA, let's just assume they had a service agreement with the client. They fired the client. And now, after they don't have that engagement anymore with the client, now a participant comes back to them. So is there a time limit on, in your service agreements, does it say, if companies part, that's it, we're done, it's all null and void, or...
conflicts are forever.
Okay.
Yeah, basically probably what I would say in that circumstance is, again, listen, I worked for the company, they're no longer clients of mine or whatever. I might want to say, you could go onto the Department of Labor's website where it will show you what your rights are as a participant, because then I'm not giving out any information that they couldn't legally find out on their own with a web search. But generally speaking, I would probably, unless I knew that something really bad was going on, if I knew that these guys were not making deferrals and they were going to go broke and these people were going to be without, then I would definitely point them to the DOL's website. But in absence of that, where it's just, I don't like my employer, they're being mean to me kind of phone call, I would basically say, look, that's not what I can do for you. I worked for them and I need to keep what they told me inviolate.
Okay. One other quick follow-up, and then we can move on. Per our earlier question, Q&A, if you think that your client has deferrals that were deposited late and outline the rules to the client, but the client does not want to answer the 5,500 that the deferrals were late, do we still have to complete the 5,500 saying that the deferrals were late? I could answer that, I think.
Yes.
I would say yes.
Yeah. And it's interesting because I don't think that we have this example in this particular session, but I have done something like that, or we've done something like that. Yeah, when we've done these before is, so what do you do when a client tells you not to answer the question that way? And you cannot, particularly if you are a Circular 230 practitioner, answer questions wrong on the 5,500, and frankly, if your client does it, they're committing perjury. They can go to jail for that. So, one of the things that I find is really useful with clients that are of that sort of bend is to say to them, gee, you're signing this under penalty of perjury. Do you realize you can go to jail for this? And do you really want to end up a guest of federal housing over something that, the excise tax of that you would have to pay and the interest that you're going to have to pay on the late deposit is, $1.98. I mean, that's just ridiculous. And if your client is insisting on lying on the 5,500, then I would consider basically firing them, because I would think that at some point in time these guys are going to get sued, and I don't want to be standing in the way when they are. Because lots of times when there's a lawsuit, you just get hit with the same brush, and you're going to end up trying to get out of a lawsuit and blah blah blah. It's a bad omen, I think.
When the fertilizer hits the fan, it gets spread all over the room.
Exactly.
With that, ladies and gentlemen, we have a number of cases that we're going to present to you. And so all of our players, get ready here. We have the case of the terminated administrator. We opened the scene at the office. By the way, there will be questions at the end. We open our scene at the offices of Alex, the TPA.
Jordan, we're really sorry to see you go. You've been with us for 5 years, and we really like having you as an employee. But we understand that your wife is being transferred to Mozambique, and the commute is just too far. Best of luck to you.
Thanks, boss. I'll let you know if I need a reference for a benefits job in Mozambique. In fact, I'm not really even sure if they have benefits in Mozambique.
Yo, Taylor, will you come in my office, please?
Hey, Alex, what can I do for you?
Well, Jordan just gave his notice. I need you to take over that caseload till we find a replacement. All right?
Not a problem at all. I'm happy to double up my caseload while you've been standing here for the last month waiting to fill this position. I'm happy.
A month passes, and Taylor knocks on the door.
Cue Taylor.
Alex, we've got a real problem.
What's up?
Well, you know, I've been working on about 10 of these cases so far, and they have all come up with some pretty significant problems. I don't even know what Jordan's background was, but he sure doesn't appear to know what he was doing. For example, we have an incorrect allocation on some cases with matching contributions and no ACP, and the documents don't even seem to match the administration.
Every case is like this?
Well, some are worse than others, but nothing is clean so far.
Holy moly. I need to think about what we need to do.
So, ladies and gents, we have a question here. What's the first thing Alex should do? Should Alex review Jordan's cases to find out just how bad the problems are, send a letter to the clients informing them of the problems and promising to make it right, contact his E&O carrier, or have Taylor sign a non-disclosure agreement, then fire Taylor? So what is the first thing Alex should do? Review the cases to find out how bad the problem is, send a letter to the clients, can Taylor, or contact the E&O carrier. Wow. There's almost uniform agreement here. This is unreal. I'm going to close this off very shortly because the agreement is so complete. You've got about 16 seconds. What's the first thing you would do?
Is that a cue for Alex?
No, not yet.
Okay.
The number one answer, just far and away, is review the cases to find out just how bad the problem is before you do anything else. 22 of you, 2% of those who responded, said, oh, let's send a letter to the clients. And just a few more said, let's contact the E&O carrier. And I'm glad nobody wanted to fire Taylor. Eileen, what do you think the answer should be?
Well, a couple of things that I think are really important. The first thing is just from a practical standpoint. I just want you to picture that you're a business owner and say you have 500 clients. Let's say that it's this time of year, so it's the end of March, early April, 5,500s are coming up. You're doing testing and everything, and this guy has 100 plan caseload. And how is it that you're going to drop everything and review his cases? And that,
we're going to get to that as the next question, in fact.
Okay. So that's something to think about as you're coming up with this. The second thing to think about is that you really do want to look at your E&O insurance policy, because quite commonly, if you don't notify the E&O insurer when you know that there are potentials for claims, that you could end up voiding your coverage. And we had one case that the E&O insurer at least started out, we convinced them otherwise, but started out initially saying that they weren't going to basically give them coverage because they should have known a year earlier that they had a potential claim, and they did not notify the insurer. So you really want to make sure as to when it is in this process your insurance policy requires you to notify them. And I should let you know that just because you notify them that there may be a potential for claim doesn't mean that your rates are going to go up or they're going to drop you or whatever. What it does is it starts the ability for you to be covered for issues, and you basically lose the risk that they're going to deny coverage. Another thing also that you need to know is that before you admit fault, you must talk to your E&O insurer. Most E&O policies that I've looked at have a provision that says if you admit fault without talking to them first, that it voids your coverage out. So if you get on the phone with one of these clients and say, oh, I'm really sorry, I just realized that this guy screwed up your case and we're going to do everything we can to fix it, and an audit notice comes out tomorrow before you have a chance to VCP it or whatever, the insurance company is going to basically say, we're not going to cover you because you admitted fault. So you got to be very careful about this stuff.
Alex, what are some of the things you're thinking about?
Well, I could fire Taylor and give those cases to my most junior administrator. No one would ever know. Oh, man. Or I could shut down the office for a week and we could all look at Jordan's cases to find the errors and figure out what to do. Or I could just have Taylor report back to me on a case-by-case basis as she finds errors. Oh, man. I wonder what my liability for all these screw-ups is. Thank God I have good E&O.
So, if you were Alex, how would you go about discovering the problems? This is the first issue that Ilene raised. Would you shut down the office and go through the cases, take them as they come in the course of administration, hire extra employees and pay overtime to review the files, or just ignore the past and play audit roulette? Deal with them as they came up under audit. Interesting. We do have responses for each of the four answers. This is in many ways a tougher question. Interesting response. 20 seconds.
This is Jordan speaking. I'm just amazed at how fast I'm being thrown under the bus.
Well, you know, you go to Mozambique, and that's what happens.
You mess up, you pay.
All right. So, of those who responded, the number one answer is take them as they come in the course of administration. But a decent number of folks would say, let's bring on some extra people, not necessarily close down the office, but let's take a look at this and see what it is. And there are some folks that would say, let's just close the doors and figure this out before we go on. And not many of you, I'm pleased to see not many of you, went with audit roulette. Ilene?
Well, and again, I think that this is really a very practical practice kind of question as to, what can you afford to do and what can you not afford to do? I mean, I think it would be very difficult on a practical basis. I've never known that people were sitting around not knowing what to do with themselves. I mean, they tend to be very, very busy, and they tend to not have a lot of extra staff. And so the idea that you're going to somehow shut down your office for 2 weeks and go through all these cases, I mean, I just don't know how practical that is. On the other hand, if you're going to do what is probably the more practical answer, which is, hey, what we'll do is, as the year goes by, we'll be reviewing every case. We'll come across them as they come. You're running a risk that the plans are going to be audited in the meantime, and you're going to end up worse off. I might consider talking to my E&O insurer and see what they recommend in this circumstance. I might also see if part of the coverage might be that they will cover the cost of somebody to diagnose the error, so that maybe, rather than having to do this all out of pocket and have no profit for that year, they will insure part of this process. So, I mean, I think that there's no real right answer to this. It's what you can afford to do and what you feel comfortable doing. Another element, I think, is also, are you going to sleep for the next year? If you dawdle on doing this, so you're doing it all during the year, is this going to be just a year from hell for you, where you're just going to be terrified all year long? Because if that's the case, then there's probably a real value to you taking care of it more quickly than not, because you just need to be able to do that in order to go on. So there you go.
Let me add, this is not the type of thing where a group VCP filing is really available. To the extent the corrections are going to involve VCP, it's going to have to be done on a case-by-case basis. So there isn't necessarily something to be gained by just closing the doors and figuring out what's there. You're going to have to resolve them on a case-by-case basis, and particularly since the errors sound like they're all over the place. Next, so let's think about this. Suppose Alex calls Taylor back into his office.
Well, Taylor, I've looked at our E&O coverage, and I'm worried about this mess up with Jordan. I think our best move is to just forget the past and just do it right from here on out. So stop checking Jordan's work, assume it's right, and let's just move forward.
But boss, I'm an IRPA.
So what? I'm not, and it's my firm.
So now, and this came to me from the IRPA employee. All right, my boss couldn't care less, but here I am, and I'm registered before the IRS. What should I do? So what would you do if you were Taylor, the employee who found all this? Your possibilities are quit. Try to persuade Alex and quit if Alex doesn't listen. Quit and blow the whistle on Alex to the IRS. Be quiet and cash your paycheck and follow your boss's instructions, or put a client as some other approach in the Q&A box.
I'm moving to Mozambique.
Not after what you said to me about me.
We all had rumors that you had something going with, the guy.
Do you realize how far away Mozambique is?
No Starbucks. I'm not going.
This one is taking folks longer to think about. And I guess that's not surprising. We've got about half of you have answered. You're not being graded on this, okay? So give it a shot. I'm going to close this off in about 20 seconds. Overwhelming. The majority answer is try to persuade Alex, but if Alex won't do the right thing, then quit. The number 2 answer was shut up and follow orders. And it goes down from there. Comments, anyone?
Well, I think that
I'm looking at some of the comments we've got. Rather than lose my job, ask for it to be assigned to someone else that will follow the directions. Try to convince Alex, but quit and report it to the IRS if that doesn't work. Lovely to rat out the boss. Refuse to do Alex's bidding, get fired, collect unemployment, and then report him to the IRS. Send an email to Alex stating your approach would be to have someone review Jordan's work to correct any deficiencies, so that you've got something in writing that you've tried at least to get it right. Comments, thoughts? Let's move on to the next scenario then. And I'm out of this one, so.
You are.
Number
so
two.
I'm your narrator for this one. Okay, so we have Brett, who's an owner of a TPA firm, and we have Tracy, who's a new staff TPA. And we start with Brett.
Tracy, how's the audit of the ABC plan going?
You don't know this, but I'm fresh back from Mozambique. It's been a real bear, but I think I may be making some progress.
Well, they don't usually let administrators with less than a year service handle IRS audits, but you've been doing so well since you started working here that I thought you could handle it. Tell me what's been happening.
Well, first this agent asked me for all kinds of information, you know, plan documents, testing, distribution forms, deferral elections, all kinds of stuff. Really, it was an unreasonable amount of stuff.
Well, I'm not really sure how unreasonable that is, but what did you do?
Well, I stalled the auditor off as long as I could. I told her that she didn't really need all that kind of stuff, and we didn't even have a lot of it anyway. She could just call the prior TPA if she wants that old junk.
Gee, I'm not sure that was the best approach. What happened next?
Well, then she was making a big deal about a check from the plan to the owner of ABC. I didn't tell her what it was about, but it looks like it was an improper distribution. I'm thinking that I'll just make up loan documents and have the client backdate them. That should shut her up.
Oh, my goodness. What else?
Well, then the IRS chick called me today and got really testy about the data request that I haven't responded to. Well, her tone really made me mad. After all, she works for us, doesn't she? I mean, we pay her salary with our taxes. I told her that, and also told her that she could put a request where the sun don't shine, if you know what I mean. Boy, did she get huffy then.
Tracy? Check? What are you thinking? This is the IRS we're talking about.
Yeah, you know what? Those bullies don't scare me. My dad says you just got to be firm with those government people.
And so the question is, if you were Brett, how would you handle the IRS? And this is a check all that apply. 1, apologize profusely. 2, take over or over, if you prefer, handling the audit personally. 3, correct the misstatements. Or D, ship a bottle of bourbon as an apology. We won't take a lot of time with this one.
It sounds like I came back with not only a new identity, but a big attitude from Mozambique.
20 seconds. What amazes me is how many people would have shipped the bottle of bourbon. This is called a bribe. We didn't cover this. I didn't think we needed to cover this. That's really bad. Yes, so you take over handling the audit personally. Of course you do. You correct the misstatements, and yes, I think that, you know, Ilene, from your standpoint, what would you be doing?
Oh, God, I would be so apologetic. I mean, I would absolutely get on the phone and say, I'm so sorry, I was shorthanded and I assigned this guy, and clearly I made a mistake. And could we please just start back from the beginning, and let's go back through this again, and I will certainly get you everything you want yesterday, and blah blah blah. I mean, I think that one of the things that we have to remember is that the IRS, they're people too, and I know that a lot of people don't think so, but they really are. They're not zombies or anything else, and that in large measure, they're just trying to do their job as well. In addition to that, we certainly don't want to prejudice our client in a situation where we may need the IRS to help us, because as we know, every plan's got defects in it. No matter how careful we are in administering it, so the last thing we want to do is for them to take our client to the cleaners because we have been rude and uncooperative and everything else. So yeah, you just really want to just throw yourself on the mercy of the folks. To me, and tell me, Derrin, if you hit this on the polling question, what's much more interesting is what do you do with Tracy?
And that will be, in fact, our next question. So the question is, what do you do about Tracy? And your choices are fire Tracy, not let Tracy handle an audit, certainly not without a lot more training, or give Tracy a raise for having the guts to speak the truth to power.
I vote for C.
Okay, everybody's figured out that the correct responses are either quit or retrain, fire or retrain.
I feel a little sorry, actually, for Tracy, even though Tracy is clearly a twit and, immature and everything else. The fact is that he was thrown in the deep side of the pool without any training. And I think that the fault for this problem really, really lies with the owner of the company, and that he has actually been unethical for having somebody handle this matter that wasn't trained to do so. So, I feel sorry for Tracy. On the other hand, like I said, he's an idiot, and he's shown a complete lack of judgment, regardless of the fact that he wasn't well trained. So on the one hand, I'd like to say, I would spend more time with him and train him and teach him the right way to do things. On the other hand, I can't believe I was such an idiot that I hired this dope. So somewhere in between those two is the right answer.
Well, I am content with canning Tracy on the grounds that I really shouldn't have to train somebody, that you don't tell an IRS employee to put it where the sun don't shine. That's beyond training. I could see an argument in favor of stall them, fight over things that aren't important, but this is a person who is willing to lie to the IRS, and this is a person who went out of their way to insult the IRS. Those are my justifications for canning.
I mean, I have never talked to somebody like that in my life, much less to an IRS agent. So, I have real doubts that this guy's going to be a good employee at all. But at the same time, I mean, obviously we had this scenario to be very extreme and everything. I would hope that you don't have somebody who really in real life is that rude. But nonetheless, yeah, I'm with you.
All right, next scenario.
Alrighty.
All right, and so I'm narrating this one. We open our scenes at the offices of Parker's Potatoes, the plan sponsor, where Parker, the owner of the company, is meeting with the TPA.
Well, I now must own a TPA firm. So, okay, Parker, so we just finished having you electronically sign your 5500, and here are the participant statements for your people. That just about does it.
That's great, Carson. As usual, you have done a wonderful job on the annual work for a plan this year.
Thank you very much, Parker. My people rock. One last thing, and then I can take you to lunch. We are looking at our files as a part of this work, and we realize that we don't have a copy of the amendment we prepared for you 3 years ago to add automatic enrollment to your plan.
Okay, well, no problem. Give it to me, and I'll sign it now.
Well, that would be a problem, as amendments need to be signed by the end of the plan year in which they are effective. As this amendment was effective 2014, it should have been signed by December 31st, 2014.
I'm sure that we have that someplace. Can you show me what it looks like?
Well, I happen to have a copy of what we sent you right here. Can you check it out and see if you have a signed version?
Yeah, give it to me. I'll go back and check. Okay, Carson, we found it. Here it is.
Oh, terrific. Oh, good. It's signed December 30th, 2014. Perfect. Oh, no. What?
What's the matter?
Well, I just got ink all over my hand. And your signature on the amendment is smeared. Uh-oh.
If you were Carson, what would you do about the amendment? Patiently explain why a backdated document won't do. Put it in the file. Carson, after all, Circular 230 says Carson can take his client's word for it, or fire the client. $20 seconds.
Don't need a little Jeopardy music or something here.
Dun, 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 dun,
Do you know that the person who wrote the Jeopardy theme has made millions in royalties
I bet.
with the final Jeopardy music? All right. There's the runaway answer is patiently explain why backdated document won't do. You have to make reasonable inquiries. I misstated the rule. I did so deliberately. You cannot accept things that appeared to be inconsistent with known facts. And with the smudge stink, you cannot just take your client's word for it. For those who would fire the client, I can understand that, with the notion that this client is very likely to be more trouble than they're worth. But personally, I would try to explain it first. All right, suppose...
Can I add to that? Just
yes.
a second. And that's that, most clients don't know, and in fact, a lot of TPAs don't know that backdating a document is tax fraud. They just think that they need to present you with what it is that you asked for, and that it's totally innocent. So before you assume that somebody's dishonest and rotten and horrible and terrible and all those other things, explaining to them that that's not ethical, I think, makes a certain sense. That, look, guys, if that were to be discovered, that the IRS would consider that to be tax fraud, you can end up in jail for that. There's also a plethora of stories that if you've been in the industry at all, you might have heard from people who work for the IRS, where things were presented to the IRS that like that had language that Congress hadn't passed yet when this document was supposed to be signed, but it's embedded in the document, or things like that where fraud was found out, and the IRS actually did punch somebody's ticket for them, and basically made it so that they couldn't practice anymore, or sent them to jail or something like that. So I think there's a value to telling your client why it is that this is not appropriate.
I think we go on to number 4. Ilene, this one's yours.
Okay. I'm sorry. You mean case number 4. I'm sorry.
Yep.
Okay. Oh, sorry. Give me just 1 sec. Here we go. Okay. So here we are, the case of the undependable program. We have Cassidy as the owner of the TPA. So, Tim, you still?
Yep.
Okay, so.
And we have Shelby, the new TPA, or the TPA manager. So Joanne is the manager, Whitney's the newbie, and Tim is the owner of the company. And we open our offices, or our scene at the offices of Cassidy and Cassidy, a TPA firm with Cassidy the owner, Shelby the manager, and Whitney the new hire just right
Mr. Cassidy, thank you so much for hiring me, given my background and all. But I never thought I'd get a job right after graduation, even though we Georgia Tech folks are all brilliant.
Tech, huh? Well, I may be a University of Georgia graduate, but I was really impressed with your skill. I will look forward to starting work on cases once you're through our 2-week training program for new administrators.
Okay, Whitney, be here bright and early in the morning tomorrow as we have a lot to teach you.
Okay, I can't wait.
What a
Out the
bright
door.
kid. I think Whitney's really going to work out well.
So a month passes, and Whitney's working on cases, and one day he approaches Shelby.
Shelby, I was wondering if I could talk to you about something.
Sure, Whitney, what's up?
I was working on the Jones 401k.
Wait. It's supposed to be the newbie that's talking to Whitney, not the business owner. Stepping on Tim's line.
No.
Working on the Jones Company 401k plan, and I ran it through our computer system for the APD test.
The ADP test, Whitney?
Yeah, whatever. Anyway, I decided to try to do the test myself by hand, just to see if I remembered what you taught me in training. And when I ran it by hand, it seems to me that the test fails, but the computer says it passes.
You know, Whitney, you must have done it wrong. Something must be wrong. Cassidy programmed that system himself, and we've been using it for years. You know, don't worry about it. I'm sure it's fine.
So another month passes, and now Shelby's meeting with Cassidy, the owner.
That twerp Whitney is making me nuts, Cassidy. He thinks that he knows everything about the TPA business, and he's just only been here a few months.
Shelby, have some patience. Whitney's a kid.
Okay, well, let's see how patient you are. Whitney insists that your ADP testing program doesn't work right.
That's funny. I'm sure it's great. What does he say is wrong with it?
Oh, something about the 2 plans, 2 times test, something, I don't know. I just don't even listen anymore. It's always something with that know-it-all.
Well, maybe I'll check it out just to be sure. If nothing else, I can use it as a teaching experience to show Whitney where he is going wrong.
So Cassidy checks the program, and
oh my God, that twerp is right. The software is doing the calculation wrong. We've been using this program for years, and it looks like every case using the 2 + 2 times rule might be wrong. Maybe I'll just fix it and move forward. After all, no one but Whitney has found the problem in all of these years, including the IRS. Of course, if Whitney tells anybody else, it'll be really embarrassing. Maybe I should get rid of Whitney too.
So, what should the owner do first? First, have Whitney sign a non-disclosure agreement, and then fire Whitney, admit the error to clients, contact the E&O carrier, fix it going forward and ignore the past, or check to see how many clients were affected.
This is bordering on character assassination. I just want you to know that.
We're sending you back to Mozambique. With a bottle of bourbon.
All right, there are only 2 answers coming in here. 20 seconds. I got the idea of the non-disclosure agreements from current headlines, I'll have you know. Okay, so the 2 answers are check to see how many clients are affected and contact the E&O carrier. Boy, to me, this is a clearer case for contact the E&O carrier as one of the first things you do. Eileen?
yeah, no, I absolutely agree. And the other thing also is that this is a systemic error. Now, this is a problem where your program is making a mistake and it's making it over and over again. So you will be able to file this under the Group VCP program, which means that all these things can be reviewed at the same time by the IRS for one not insubstantial fee. And so there's definitely an advantage to identifying each and every case in relatively short order and getting it all covered under the group BCP program. So I think that that's the right thing to do. Again, you're going to have issues with staffing of that process and how to do that without basically closing down shop for a period of time. But it's going to be a good thing to do because it's going to really put you in a position to deal with it quickly.
Assume as a result of the glitch, there was one plan that failed the test 5 years running and hasn't been caught until now. What would you do? Would you try to self-correct it, file it under VCP, or just take your chances? Five years running. 20 seconds. Lawyers on the panel, all our panelists, one of the standards in terms of do you self-correct a significant failure that's gone more than 2 years, or do you file under VCP, is the failure significant? If you were advising the TPA, would you tell them this is a significant failure and suggest that they file under VCP?
Well, I probably would. I think that it's going to be hard to make an argument that when you've been in error for 5 years in a row, that it's insignificant at that point in time. Basically, insignificance or significance is judged under EFCRS on a series of factors, one of which is, how much money is involved, how many participants are involved, and things like that. But another one is how many years has this happened over? And this has happened over a significant period of time. So I think it's a much tougher nut to crack in terms of whether or not you can argue that this is insignificant in light of that information.
I'm with you, Ilene. I would be recommending going under VCP, and most everybody here said yes, we would file it under VCP. Obviously, the practitioner in a case like this is going to be on the hook for the VCP filing fee. This is why you pay up your E&O. I think we're out of time, so that will complete what we're doing here. Chuck, take it away.
Okay. Let me see if I can share my screen real quick. I wanted to give everybody a quick view of Aristopedia.com, some of the content that Derrin and Ilene work on for us. So if you haven't seen this, we can certainly give you a one-on-one presentation, but Qualified Plan e-source is our 21-chapter Qualified Plan Compliance Information Source. And Who's the Employer is Derrin's now 7th edition title on employee aggregation issues and controlled groups. All of this can be searchable, whether you see in our little search bar, or you can just open up the titles and it reads just like it would in print. In Derrin's case, it's a lot of Q&As, right, with examples. Everything is hyperlinked to case law or supporting code and regulations. And you'll notice this little question icon here. The question now are being answered by Derrin. So when you send in a question, you either get an email or sometimes a phone call back from Derrin trying to give you some insight or extra amplification or clarification on an issue that you might find that you just can't understand after reading all these clear-cut examples and explanation. Again, we'd love to give you a one-on-one demonstration. If you're interested, you can always go to our home page, Aristopedia.com, where you will find, I go to the right place.
And I should mention that Derrin will answer questions on all the topics in all of the books, not just his. That's
true. Derrin answers any question that's submitted on all the titles, and including the Qualified Plan e-source has some limited coverage on, say, for instance, 403B plans and 457 plans. He does try to answer those questions as well. But you can go to our homepage where you can get information about our products. You can see our pricing, and this is where you can also find out about upcoming webcasts, including the rebroadcast of this, which will be live and will qualify for CE. We know there were a number of people who did not register in time for this conference before it filled up, so we will be running it again on April 10th, so you can tell others in your office or other people that you know that might be interested. Our broadcast announcements of these webcasts typically goes out to our customer database first, and then a few days later or so, we send out a general broadcast to anybody who we have in our database, so they can fill up fast with customers, and sometimes we're having to do it a second time. And even those are filling up. I think we already have 400 or 500 registered for the one on April 10th, don't we, Tim?
Yes.
So that's that. You can reach us here. You can sign up for a trial. You can contact us. Our contact information is at the bottom of every page. You can write to support or sales at Aristopedia or call us. Now that you know we all have multiple personalities as different characters, we are fun and we are human, as Ilene said. We're just like the IRS. We're human. Thank you for your time, and we did run over a few minutes, but we appreciate it. Hope you found this webinar of interest, and thanks for joining us.
Thank you so much.
Everybody.
Thank you.